So this is Unit 13 of the class where we discuss state governments and specifically California. At this point, I want to highlight exactly why the Cal State requires this course to have this component, this unit. As a government, California is massive and it's really important to the rest of the nation. In addition, at this point, each of you are residents of California. You're getting a degree from the state of California. And as a public institution, the CSU is an entity of the state government. The state government has a vested interest in making certain that its graduates are knowledgeable about state processes and government. And one of the most common refrains that I informally hear is that California is too expensive to live, or California taxes people too much. Thus, I think it's just really important to have a unit which discusses some of this, and it highlights how state government works. So to start this video, there's some facts. California has over 38 million people living in it. That's far more than any other state. California also has a massive economy. Last year, the state earned $2.7 trillion, and the GDP of the state is growing each year. And to put this in perspective, $2.7 trillion makes California the fifth largest economy in the world, only surpassed by the entire United States, Japan, China, and Germany. And we should think of California as having its own laws. As a resident, you're implicitly agreeing to live by these laws. There's a California state constitution. It looks somewhat like the national constitution, but our state constitution has been amended over 500 times. We have a California executive, which, might look a little bit like the presidency, where it's led by a governor, but the governor also shares power with 7 other offices, which we don't have at the national level. We have a state legislature, but instead of 535 members, we have 120 members in the Assembly and Senate. And we have a state Supreme Court, a lot like our national Supreme Court with a 3-level tier system. In California alone, the court system considers over 10 million cases. And in addition, there are an additional 5,000 plus governments that are considered to fall under the state, such as county, city, and school districts. So from this really short conversation, it's clear that you could run a whole class on just California government. In fact, our department offers a class every semester on California government. And California is a peculiar state. It has a full and rich, controversial even history. We tend to think of California as heavily Democratic, heavily blue, but in its history, it's also made some really interesting policy choices. For example, the state spends around $6,000 a year on your education, but it's going to spend around $50,000 a year on each prison inmate housed in the state. Incredibly, the official language in California is English. That's curious, especially considering there is no official language in the United States. California also once banned undocumented immigrants from obtaining public services in the state, including healthcare and education. So it's clear, right, that there's a lot going on in California, and it's not really what you would initially think about a blue state like California. But before we move on to the agenda, I'm going to highlight 3 important aspects as to why it's important to study state politics. First, California is a beacon for the rest of the country in the way that it's multicultural and diverse. California looks far different than it did just 40, 50 years ago, and the state is undergoing a significant transformation that is really indicative of the patterns happening across the country. Our Latino and Asian populations, for example, exceed those of other states, and we're kind of the multicultural trendsetters of the country. Second, this earlier fact that I stated, given that California is the 5th largest economy in the world, we produce more in goods and services than the country of France or the country of the United Kingdom. However, the state, because it works really close in contact with the national government, has less control over the economies than maybe the nation of France or the UK does. And third, which I'll talk about in this lecture, California relies more on what we call direct democracy than most other states in this nation. The public, citizens, have a large degree of influence on the policy that's made in this state. Citizens make really important choices and decisions based on what they really believe. And our representatives in California are even held to a higher standard than most other states. So for the agenda in this class, what I'm going to do is first cover the California Constitution, talk about this document that we have at the state level, and describe why it might be different than what we learned in the national Constitution. The second thing that I'm going to talk about is innovation. Innovation is a really important aspect of California, but it's how we should think about all state governments and maybe even local governments. There's a really neat Supreme Court case that I'll discuss in section 2 of this class, which kind of gets at this innovation. And then part 3 will refer back to this process that we call direct democracy. Direct democracy is when citizens have a direct say in legislating. And this isn't something that happens in every state across the country, but this is a big component of California politics and how it works. In part 1 of the video where I talk about the California Constitution, I really just want to start really generally by maybe discussing how constitutions work. So we covered the U.S. Constitution earlier in the class. However, multiple governments, multiple countries have their own existing constitutions. And constitutions aren't necessarily written for democracies. Constitutions govern all types of countries. For example, China, Iran, and Pakistan all have constitutions. So we often hear the Constitution in reference to our own national document. That's kind of what we think when we hear the word Constitution. But when we say just Constitution, generally speaking, it's really just a document that formulates the basic structure of government. That's how we talked about it in the first couple days of this class. And in reference to these documents, it's basically making choices, decisions about who gets what in terms of power. In the United States, we have this national document that we learned about how power is allotted in federal government. It details the power and connections between the 3 branches, sets up the institutions in Congress, the presidency, and the Supreme Court. But it also lays the structure of the Bill of Rights, which are our fundamental freedoms that the framers thought were important enough to include in this document. But you should know that in addition to the U.S. Constitution, each of the 50 states have their own individual documents. They have their own individual constitutions. So this kind of sort of picks up this really early conversation about federalism. Each state has its own governor, separate from the federal government. And underneath the states, we even have local governments, over 5,000 in California. But federal, state, local all work together to provide citizens the opportunity to have their voices and opinions transform into public policy. And one of the things that we should remember in this conversation of federalism is that the framers really vested a lot of power in state governments. They understood the need for a powerful central authority like the national government, but most of the colonists wanted power to be held in state governments. They were worried of this overreaching central government, and they didn't want a monarchy, so the framers were smart enough to institute the 10th Amendment. We've talked about this. This is all review, right? The 10th Amendment is the powers not delegated to the states are reserved to the states. So the 10th Amendment basically gives states the power to do anything that the national government doesn't. Thus, the way that we think about this today is that as citizens, residents are obligated to follow several documents at one time. So if you live in California, you're following the U.S. Constitution, but you're also following the California Constitution. You might also be obligated, and you don't even know, to follow charters and constitutions at the county level or the city level. But nonetheless, these are laws that kind of dictate how power works in government. So now in this juncture, what I want to do is just really only talk about the U.S. and California Constitution, because we spent so much time at the beginning of class talking about the U.S. Constitution. Let's compare that to what I want to talk about with the state constitution. So in discussing these institutions, these branches of government, Congress, the presidency, and the Supreme Court at the national level, I always stopped and discussed Articles 1, Article 2, and Article 3. And these are the parts of the U.S. Constitution that specify power in the branches. And each time I came to that conversation, I remarked at how incredibly vague each of these articles were, and that they weren't really explicitly laying out power for the branches of government. California is really different. California, its constitution is much more specific. It's much more detailed. And for the most of this class, we've been discussing the benefit to having a pretty vague document. It's allowed the United States government to be open to interpretation and how to evolve to solve the country's problems, which we've kind of detailed has been pretty extensive in the history of the United States. Some people argue, actually, though, on the other hand, when you have a specific constitution like our state document, it can actually be pretty helpful in solving other problems that might come up. One thing to consider at this juncture of the conversation is that the average life expectancy of any constitution across the world is only 17 years. So most documents that countries or governments institute last for, almost a little bit more than a dozen years. In the United States, we praise our Constitution for lasting over 225 years. It survived the Civil War, the Civil Rights Movement, and the document is vague. But similarly, you should think about California as lasting more than 100 years, and that document is insanely detailed. So given the idea that most constitutions have a short lifespan, what makes both the U.S. and California constitutions successful? So it might not even be about the length of the Constitution or the specificity of the Constitution, but it's about what I'll call adaptility. Adaptility is about the document's ability to adjust to different new situations, crises that might arise, and the document's ability to respond to the needs and wants of citizens and basically allow government to change and reflect these needs and wants. So the ability of the constitutional system to adapt to changes in its environment really determines whether or not the document will continue to exist over time. So most governments don't have constitutions that have a flexible formal amendment process or effective mechanisms where the document can be interpreted. California's constitution might be long, it might be confusing, but nonetheless, California's constitution is fairly adaptable. So I want to talk about the Federalist Papers here. Now, the Federalist Papers we've talked about before in this class at different points, but they're a series of essays that were written by the framers, and they really tackle various aspects of this new government that they set up with the Constitution. They were attempting to basically promote the Constitution and ratify it with these essays, but it's really important to understanding the intent and purpose of the framers. So Federalist 46 specifically deals with the issue of state government. So remember, the colonists were afraid of replicating a government similar to that of England, and many of the colonists and early Americans preferred power to be in local governments and state governments. So the main argument in Federalist 46 was that the power of the federal government would not supersede that of the state government. Quote, many considerations seem to place it beyond doubt that the first and most natural attachment of the people will be to the governments of their respective states, end quote. So the framers really thought that while both the federal and state governments were dependent on the people, ultimate authority really rested in the state governments because it was closer to the people. And this system of federalism gave the state and national government different powers with different functions and purposes. But ultimately, state governments had more power because they were closer to the public. The public could keep both federal and state accountable because they were closely connected to the state. And this is, for Federalist 46, what gave government legitimacy. The closeness of the public to state government really made state governments more legitimate and, in the framers' eyes, more powerful. And remember, the framers were, in writing this, trying to quell the sentiment that this new constitution would be unsuccessful because of the power it gave to the central government. So here you have a really nice essay which kind of describes, okay, if we really are a democracy with these tangential local governments, power really first rises with these state and local governments. And they detail this extensively in the sense that the federal government really couldn't exist without states. Federalism is set up in a way that it's highly unlikely that federal laws would be inconsistent with what's happening in the states. If states were ignored by the federal government would be found to be corrupt and basically delegitimized by the general public. And people would be more sympathetic to states. Just like you favor your home team, you'll favor representatives who live where you live, are closer to you, you're more likely to support your local congressman instead of a president in the framers' eyes. And state governments were going to be more personable, dealing with issues that were closer to the public. And at this time, state governments had the power to resist federal government. And this is just a really finite point about raising armies. During the founding, the U.S. Army wasn't ever envisioned to be this big entity, and the power of the U.S. Army would be nothing in comparison for the framers to the state militias. So in thinking about state and national governments in this way, states were seen just to be more favorable in general. States were more likely to advocate for popular causes, and laws would be decided according to the need of the public. States were basically powerful entities because they were given more power by the public. So part of this is really considering whether or not this line of reasoning is true today. And you have to remember that these documents, these essays were written over 200 years ago, and the context and the situation is very different today. Our ideas of representation and what the country works and how the country works is radically different. For example, our delegates to Congress don't travel to Congress on horse and carriage for days to go and vote on laws. Today we can send a quick email, hop on a private jet, and fly to Washington, D.C. So the question should be, is the national government more powerful than the framers intended? The answer to this is yes, right? We know this from our different units in the class. We talked about this with selective incorporation and the expansion of federal power. But have states become less powerful in this process where the national government has become more prominent? Not necessarily. You shouldn't think of states as becoming less powerful. And it's because of how we think of states and their role with the national government, principally thinking of states as being innovators in a way that the national government couldn't ever be. So the state governments really do a nice job at innovating with law. And let me discuss what I mean by talking more about the Constitution and its specific provisions. So I'm going to pick up this idea of innovation in a second. So California's Constitution is fairly long and detailed in comparison to the U.S. Constitution. In standard print, the California Constitution is over 100 pages long, double-spaced. There are 22 articles in the Constitution. Article 4 covers the legislature. Article 5 covers the executive. Article 6 covers judiciary. But, with 22 articles, we have topics such as water, education, taxation, labor relations. There's even an article on motor vehicle revenues in the California Constitution. So just by these descriptions, you see that California's priorities are very different than that of the national government. And in actuality, today's document is much longer than even the original document that was passed in the mid-1800s. And that's because the California Constitution has been amended hundreds of times. And the number of amendments in which the document has fluctuates. So sometimes these amendments are rejected later on, and it's really kind of hard to keep track of. The U.S. Constitution is much more organized. It has numbered amendments, and it doesn't replace or strike them off the record. For example, the 18th Amendment in the U.S. Constitution prohibits alcohol, but that still remains the 18th Amendment. It will always be the 18th Amendment. But in California, we have over 500 amendments in the state, and some of these have been struck from the record. So it's difficult to keep track of these. At one point, because of these amendments, California's Constitution had over 75,000 words. And to put this in perspective, the U.S. Constitution only has 8,000 words approximately, meaning the California Constitution was almost 9 times as long as the national Constitution. California has the second longest state constitution behind Louisiana, and we have the second highest number of constitutional amendments behind Alabama. Today, the document is only about half the length it was in the 1960s. It's around 30,000 words today. But again, it just gives you a sense of the specificity that our state document has. So let's jump into talking about the history of the Constitution and how it came up with these specific provisions. Part of what I'll talk about is which provisions are still in place today that were put in place by our state founders. So the way that we should think about the California Constitution is that California is a frontier state, right? This was once a Mexican territory, and Spanish settlers came to the United States in the mid-1500s, even before the U.S. was settled. And the Spanish colonized a series of Catholic missions across the state. In 1821, Mexico gained independence from Spain, and Mexico held on to California until the Mexican-American War in 1848. The Treaty of Guadalupe Hidalgo gave California to the United States, and in 1849, the first state constitution was written. So the same exact way in which the U.S. had a constitutional convention, California has a constitutional convention, and they met in Monterey, California. So shortly after the Treaty of Guadalupe Hidalgo, California basically called for an election for delegates to write this state document. And this convention had 48 elected officials elected to basically write the rules and provisions of this brand new state. They were basically drawn from all different areas of the state. We had 4 delegates from Los Angeles, 4 from Sacramento, 5 from Monterey, 5 from San Francisco, 2 from San Diego, 2 from Santa Barbara. So, I mean, a lot of these are mission towns, makes sense. But when we actually elected these delegates, they came from all different kinds of walks of life. We had lawyers, we had ranchers, we had merchants, military men, printers, bakers, and only 6 of the total 48 had lived in the state their entire lives. 33 of the delegates had been in California for less than 3 years, and most of them were in states or came from states that were west of the Mississippi. We had 1 delegate from France, 1 delegate from Scotland, 1 delegate from Spain. But I mean, keep in mind, right? We talked about California as being a frontier state, so a lot of these people are coming to this state because of the gold rush, and it makes sense that you have different kinds of backgrounds representing the ideas that were written in this first document. In terms of what these elected officials placed in the Constitution that's still there today, they instituted a system of checks and balances between an executive, legislative, and judiciary at the state level. So a lot like the way that we have 3 branches of government at the national level, the state government has its 3 branches of government. So we have a state legislature, we have a state executive, and we have a state judiciary. So when we talk about the state executive, most of us think of this as a governor. So today this is Gavin Newsom, but the executive is divided amongst 8 different offices today. So this was set up by the state constitution. They didn't want just one person sitting in this office. Now, a lot of people in California make the mistake that, well, these 8 offices work a lot like the president's cabinet, that the governor sits at the top and the lieutenant governor, the controller, the treasurer, the attorney general, they all serve under the governor and at his pleasure. And that's an inaccurate view. We have 8 offices today, and these 8 offices share power in the executive branch because the framers of the state constitution didn't want to give one person total control of this branch of government. The 8 offices that we have today were not included in the original version of the Constitution, so we added some of these offices later on. For example, the superintendent of public schools is considered a state executive, and so is the state insurance commissioner. But each of these people, these elected officials, have their own independent source of power. They have their own staff, and they work independently from one another. They're all potential competitors for policy, and they're supposed to check each other just within the executive. So the divided executive works really different than the presidency at the national level. Similar to the legislature at the national level, we have a bicameral legislature. So we have 2 chambers in our California legislature. We have a Senate. So at the U.S. level, it's a little confusing because we call the upper chamber, the upper house, the U.S. Senate. But at the state level, we have a California Senate. But instead of a House of Representatives like we have at the national level, we have a lower house that's called the California Assembly. So the California Assembly is basically the equivalent of the House of Representatives. So we have an Assembly and Senate in our bicameral state legislature. And just like the U.S. Constitution, California has its own Bill of Rights, but it's much more extensive. That goes way beyond anything that the U.S. Constitution did. So this is actually found in Article 1, so it's a little different than the U.S. Constitution because it's at the beginning of the document, and it guarantees a lot of the same rights as the U.S. Constitution, so freedom of speech, press, religion, but it also talks more explicitly about things like life, liberty, and property, right, our natural rights, our ability to institute grievances with the government. It also talks about the explicit ability to amend and change the Bill of Rights. So again, more specific, but some argue maybe more powerful in the regard of being able to kind of deal with problems that might come up because it's being so specific. And this is a really good example of that. Now, this detail gives far more specificity to the power that's allocated at the state level than the national government did for its own branches. But part of the danger in making things so specific is that the original California Constitution looks fairly antiquated. There are some provisions that are no longer there that gives you a sense of why you might not want this document to be so specific. So in the California Constitution, they granted the rights to vote specifically to men who were 21 years old and had residency in the state for at least 6 years. So basically, they disenfranchised a huge segment of the population in the original California Constitution. The California Constitution even goes so far to specify how the state legislature could give voting rights to Native Americans, but stops short of actually doing it. The California Constitution also establishes bilingualism in the state of California, which is not the case today. But, these antiquated provisions that are no longer in the document reflects the history of the state, right? I mean, this is in the mid-1800s. Immigrants were common in California even then, but at this time, property-owning men had power in the state. So these provisions, although they're not there anymore, really reflect maybe why you wouldn't want a document to be so specific. In sum, overall, you can see how the Constitution is much more different than the United States Constitution, but it basically sets up the state government in the way that we know it today. So I've kind of briefly described as I've been going along. We have these three branches. You should think of it as kind of similar to what goes on in the national level, but with these slight differences, especially in the executive that we talk about. So in part 2 of the class, I kind of want to shift gears by discussing this idea of innovation. So we have this kind of fundamental basis where we understand that the state power is set up through the state document, the Constitution, but more generally speaking, right, we have 50 states in the U.S. where each of these states run their own government by their own individual constitutions. So the idea and how these state governments operate is that states are kind of the guardians of innovation. They innovate through policy. And this is really established by, kind of interestingly enough, a U.S. Supreme Court case. And a U.S. Supreme Court case, there's a justice who disagrees with the ruling, who kind of explicitly lays out how we today think of our state governments and how they control the innovation behind most policy throughout the entire country. So we have 50 states operating kind of independently from one another, but in operating independently, they're kind of setting the stage for what public policy looks like across the country. Now, the Supreme Court case that I'm going to talk about is New State Ice Company versus Liebman. And this is really a specific case dealing with the selling of ice cubes. So the petitioner of the case is a company named New State Ice Company, and they had been engaged in selling ice, distributing ice in 1932. The respondent is a man by the name of Mr. Liebman, and he wanted to kind of get in this ice business and try to build an ice plant in Oklahoma in order to compete with New State Ice. So New State Ice in response sues Mr. Liebman, and they want to prevent him from building his own ice plant on the grounds that Liebman hadn't received explicit permission from the state under the Oklahoma Ice Act. So the Oklahoma Ice Act basically declares the sale and distribution of ICE as a public company. At this time in the 1930s, ICE was critical, and it was actually scarce. It was considered to be a public good. I mean, people needed ICE, especially during the hot summer months, to kind of survive. So the new state ICE company had explicit permission from the state of Oklahoma to make ICE under the Oklahoma ICE Act, but Mr. Liebman did not. So the Supreme Court case hears this and decides that Mr. Liebman could indeed build his own plant and compete directly with new state ICE. And prohibiting Liebman from setting up the company would violate the Due Process Clause of the 14th Amendment, which is about liberty and property, natural rights. So the federal Supreme Court basically stepped in and said, okay, we're not going to really try to regulate the economy of ICE, even regardless of what the Oklahoma ICE Act stated. It was under Mr. Liebman's 14th Amendment right to, if he wanted, build this ICE plant. So this is a funny case, right? Because it doesn't seem like it has anything to do with state power really necessarily, or this idea of innovation. So what am I talking about? So this idea of innovation is found in the dissenting opinion. The dissenting opinion, which is the disagreeing opinion of the court case, basically carries this fundamental lesson about state governments. And it really isn't the centerpiece of the case at all, right? So it's kind of far beyond this issue of selling ICE. So the way that we should think about this case is the Supreme Court is basically addressing the government's natural interest in regulating the production and consumption of ICE. But the reason why the government cares about this in the first place is because there's a distinct need to manage the economy, to deal with things like unemployment or underproduction or overconsumption of these goods. But what this disagreeing justice argues that making these kinds of predictions is really precarious. It's really difficult. There's a lot of uncertainty in predicting economic fluctuations. And this justice is Justice Brandeis, Louis Brandeis, and he issues a dissent, a disagreement, arguing that the court shouldn't intervene because nobody can really make these kinds of predictions. Brandeis says that the national government should stay out of this entirely because intervening would be limiting the experimentation ability of the states. The national government is limiting the state government in finding its own solution to the problem of regulating ICE. And when we limit this kind of experimentation, we discourage improvement in our society. So Brandeis kind of goes above and beyond, right? And he's no longer really talking about ICE, but he's making this point of limiting state governments. So this is really why this case is important, that states should have their own power to mold their own practices and institutions through experimentation. So Brandeis doesn't know what the answer is here to this question of ICE, but he's saying that no one really does, but the state is best equipped to deal with this, even if they have to experiment to figure this out. And Justice Brandeis, in making his point, kind of issues one of the most famous quotes about state power. And he says, quote, "It is one of the happy incidents of the federal system that a single courageous state may, if its citizens choose, serve as a laboratory and try novel and social economic experiments without the risk of the rest of the country." Thus, this isn't really about ICE, but it's about how you should think about state power. It's about innovation. It's about states trying new social and economic experiments without the interference of national government. And we should think about states as the laboratories of democracy. So this is kind of what we were talking about in Federalist 46, right? The states are closest to the public. And because of this, the states can enact policies in this kind of trial and error process. The federal government isn't allowed to really do this. They can't do this. They're too far removed from everyone. But this is how we figure out how to legislate on controversial issues. Things like LGBT rights, marijuana legalization, affirmative action. I mean, there's a long list of issues that state governments consider and have kind of hammered out before the federal government even touched. The federal government takes its lead on these policies in light of what states are doing. So this is really an argument for state power. And it really gives us kind of a clear headway of thinking of the viability and legitimacy of these state constitutions. But further than that, and kind of what I want to jump into talking about next, right? We're talking about states as being laboratories, experiments, but there's one element of state government which is a real experiment, and that's direct democracy. So direct democracy is a really good topic to discuss in California government because it's about experimentation, but it's one of the most important ways in which citizens interact with government through voting in California is through direct democracy. So in this third part of the video, I want to talk about direct democracy. And the way that we think about this is in elections. California runs direct democracy in most of its elections, particularly presidential elections. Now, direct democracy is one of the most controversial, but also at the same time, most democratic aspects of how we run elections in California. The direct democracy process is one of the main reasons why there is a high information cost for Californians who participate in elections. Now, before I jump into this, let me give you a little bit of background. When you think of direct democracy, it's a process in which citizens have a direct say in legislating. So basically, citizens are making laws. But you should specifically be thinking about three mechanisms of direct democracy. And these are initiative, referendum, and recall. Typically, when you think of this, it's in the form of ballot initiatives. California adopted these processes in the early 1900s, and it's a power that's found in a lot of state governments. But there's a section of California Constitution that directly addresses this in Article 2, Section 1. Quote, "All power is inherent in the people. Government is instituted for the protection, security, and benefit, and they have the right to alter or reform it when the public good may require." So typically speaking, in a presidential election every 4 years, California will introduce approximately a dozen ballot initiatives. And we vote yes, no on props, and they're usually numbered 5 through however many. So only 10 states have actually allowed the public to have these full privileges. They include states like Colorado, Montana, Nebraska, North Dakota, South Dakota. It's actually pretty peculiar. But California is one of the ones that does it pretty often. Not just during presidential elections, but that's when we have the most initiatives on the ballot. So we have these 3 different mechanisms, and they're slightly different in terms of what they do. So I'm going to talk about them one by one. The most frequently used is that of the initiative. So initiatives are when citizens write a law and it gets on the ballot by petition. When you introduce an initiative, citizens have to pay a fee of $200, but you also need a total amount of signatures that amounts to roughly 5% of the turnout in the last gubernatorial election. So it's about 500,000 people, give and take. You can also propose an amendment to the Constitution through this initiative process, but the total amount of signatures that you need has to amount to 8%, which is about 1 million people. So we're talking about proposing a change to a law with 500,000 signatures. That's no small task, right? And we'll talk about this in a second, but ballot initiatives are fairly frequent. Since 1912, over 1,600 initiatives were introduced, but only 338 have had enough signatures to qualify for the ballot. So Californians since 1912 have voted on 338 different things. Of those 338, only about 34% have passed into law. Now, I think ideally, when we talk about the initiative process, it's where citizens might go out there and talk to their neighbors, talk to local groups, and get support for this. But 500,000 people is a lot of people. And in practice today, when we talk about the initiative process or any of these referendum processes in which you require to get this amount of signatures, special interests have a heavy hand in passing these ballots or passing these petitions in order for it to become a ballot initiative. So the ideal nature of direct democracy probably doesn't take place the way that we think it does. All right, so that's the initiative. Let's talk about the referendum next. Referendum is slightly different. Referendum is when citizens, still by petition, consider a law that's passed by the California state legislature. So if a concerned citizen sees a law passed by the state legislature that they want to vote on, you can get signatures to have the public consider that law. And these signatures have to be equal to 5% of the people who voted for governor in the last election. So again, it's about 500,000 people. And the submission of petitions must be made within 3 months of the law being passed. If the measure is approved and it's put on the ballot, then the law basically has no effect until voters vote on the proposition. This is slightly different, right? So voters are either approving or rejecting a law, and it's much more rare than the initiative. Since 1912, referendum have only appeared about 50 times on the ballot, and it varies, but voters reject laws half the time and will approve these laws around half the time. So what are these referendum typically, what have they typically addressed? Well, some of them have focused on prohibition, so this was early on in the state's history, race and civil rights, property taxes, the death penalty, gun control. So there's a lot of different kinds of things that voters have put to a vote that the legislature has passed, but not terribly common. The last mechanism of direct democracy is recall. So recall is a process that allows voters to remove a state elected official from office. So proponents, again, must submit a petition explaining the reasons for removing this politician. But here, for statewide offices, the number of signatures must be equal to 12% of the last vote for that office, with signatures from at least 5 different counties across the state. So this is a much higher threshold. 12% of voters is more than 1 million people. But for Senate, Assembly, and offices like the Board of Equalization and state judges, the number of signatures actually is a little bit higher at 20%. So this is almost 2 million people. So recalls are more difficult. And the way that the recall works is that if the signatures pass, if the state approves those signatures, the electorate then votes first on whether or not to actually remove the office holder. So if the majority agree to remove the office holder, we proceed to another vote, and the second vote is basically a list of candidates who could replace the office holder. So there are 2 items on a ballot. In California history, only 8 state office holders have been put up for a recall vote. 7 of them were state legislators, and 1 of them was Governor Gray Davis in 2003, who was replaced by Governor Arnold Schwarzenegger. So the way that ballot initiative worked, that recall initiative, in 2003 was that there were 2 items on the ballot. The first item was, do you want to remove Gray Davis from this office of governor? Most Californians said yes. The majority said yes. And then that meant we moved on to the second item on the ballot, which was a list of more than a dozen candidates, one of them being Arnold Schwarzenegger, who ended up becoming governor subsequent to Davis. So it's interesting, right? Because in terms of innovation, this is a real kind of ground zero for innovation, is when citizens have a direct say in policy, either by actually making laws, by rejecting state legislature laws, or removing office holders. And in practice, I think it's a little more complicated than that. Today, only about half of Californian voters think that propositions are a good thing. And I would call this an element of civic engagement, right? This is a really specific, powerful instance of voting, right? It's not that you're just voting for office holders, but in this sense, you're voting for laws. So I think, again, ideally it might be good, but when you think of civic engagement, you should think about the electorate's preparedness to actually do this. And we have serious reservations about people being informed enough to just vote for office holders. What makes us think that people are informed enough to actually pass law? So part of this conversation is where people are getting their information from and how maybe elites influence this process. So when we vote on ballot initiatives, we often think of this as fairly confusing. Most Californians, because we're voting on like a dozen propositions usually, are getting their information from the voter information guide, which is a small booklet which basically describes what a yes and no vote means. But even then, when you have this booklet in front of you, ballot initiatives and the yes no vote is really sometimes hard to understand. So the way that we also should think about this is that elites do influence this process in California, and that's through special interests. Special interests spend millions of dollars not only advocating yes no on different propositions, but they're the ones responsible for collecting the petitions. When you have anywhere from 500,000 to over 1 million signatures needed to put something on the ballot, again, it's not average everyday citizens going door to door collecting these signatures. So this is actually really important in reference to when you encounter petition gatherers at a supermarket, for example. You should be really wary because those people usually are paid by signature, maybe anywhere from $2 to $5, by special interest groups to place something relatively random that they don't really care about on the ballot. A lot of us are in a rush, and some of us, to be nice, might sign these petitions. But again, especially if you're concerned about how special interests and elites have too much of a say in the process, I would strongly reconsider that. And I would also just explicitly ask, are you being paid to do this? Who's paying you to do this? What organization is collecting this? Because those are valid questions. But in reference to understanding ballot initiatives, these special interests on both sides have incentive to make this process confusing. They make it confusing because they want to obscure what the real intention behind these votes are. And for voters, when you're considering 10, 15 different propositions in an election, it can be really hard to discern what the yes vote or what the no vote really means. So one final step back, I think ideally this process of direct democracy is really indicative of the kind of innovation that might take place at the state level. I mean, this is closer to the people, right? And if direct democracy were going to happen, it should be at a level like the state or even closer, like maybe city. But nonetheless, we still see special interests at play. And only half of Californians really think that these propositions are a good thing. Only 27% of voters think ballot initiatives fall in favor of citizens. So part of this is not just a story about ideally how direct democracy works. It's just about also, in addition, how special interests might also influence this process.